Good morning. My name is Kevin Snyder of Snyder Law, and I'm an estate planning and elder law planning attorney in Irvine, and I help families plan to protect what matters most to them, their loved ones, their dignity, and their legacy. Today we're going to be talking more about the Secure Act. I just came from a presentation that I gave to a group of professionals, which is why I'm still in my jacket here, and I'm very energized about this topic. There was a lot of great conversation at my presentation about the impact of the Secure Act, a lot of questions that people had about their clients and them particularly, and I just thought it would be helpful for me to get on right now and share a little bit more about what I talked about today. I've put out some blogs and videos about this already, but I can't talk about it enough, and you're going to hear from me a lot during the year about the significance of the Secure Act. So today we're just going to hit it at a high level, especially for those that haven't heard about this yet and haven't had any exposure to it. I don't want to overwhelm you because literally I could talk hours upon hours and hours about that. Example in case today, I talked for an hour and I feel like I barely scraped the surface. So here's what we're going to talk about today. We're going to talk about the benefits. We're going to talk about the downsides, why the downside's a problem, and then some really quick overview of the solution and what you can be doing right now. So like I said, we're going to hit this at a high level. If you have any questions about this, please feel free to reach out to us, and happy to be a resource for you. 949-333-3702. Or you can reach us at the email that we have on our Facebook page. Happy to help you in any way, shape, or form. Or just put questions in the feed, too. In any event, what is the Secure Act? Well, it stands for a larger word. It's an acronym, of course. And I always forget it, so I'm going to look to my notes here. It stands for Setting Every Community Up for Retirement Enhancement. And that's because there's a lot of benefits. It passed really late in the year, December 20th, and went into effect January 1st. So it's good law right now, and it's something that you need to know about. So what are the benefits? Well, it increased the ages in which your retirement account actually begins. What that means, your required beginning date for you to start taking required minimum distributions. For those of you that have retirement accounts, you know exactly what that means. And what a retirement account is if you have a 401k, you have an individual retirement account called an IRA, or you have a Roth IRA, or you have any other type of qualified retirement plan, such as a defined benefit plan, for example. These are qualified accounts in which there are tax-deferred growth over time, and you're required to start taking out minimum distributions at a certain age. And what the Act said was, okay, we can increase that age from 70 and a half now to 72. Huge benefit, because now you can wait a little bit longer before you have to be forced to start taking out these minimum distributions. That's impactful for some because it's a tax issue. The minimum distributions might increase your tax rate, and you want to avoid that. You don't actually need the money, or you want to achieve a little bit longer of tax-deferred growth. So that is a benefit. There's a number of other additional benefits for you, the individual retirement account holder. And we'll get more of that information out to you over time. But suffice to say, if you have any questions about it, please give us a call, contact your financial advisor or your accountant. All great avenues for additional information. I'll give you an example of one additional benefit. If you're having a child or adopting a child, now you can withdraw up to $5,000 penalty-free from a qualified retirement account. Not tax-free, it still counts as income, but penalty-free if you are younger than age 72 now and you want to take advantage of that. That's just an additional benefit. There are others for small business owners and so on and so forth. Like I said, we'll get more information for you about that. But the main one on the benefit side is that you can wait to 72 to get minimum distributions out. Now, the downside. The downside is that your beneficiaries, so not you, your beneficiaries who are not your spouse will no longer be able to enjoy receiving that benefit of your inherited retirement account over their lifetime. Previously, the rule is that you can measure the length of that account that you leave to a beneficiary over the life expectancy. For example, you pass away and your beneficiary is an adult child, then that adult child will have to take out minimum distributions over the course of their lifetime. Not what your previous plan was, but your lifetime. So that is an additional benefit. that was an additional benefit from a tax perspective, because now they could achieve what was called a stretch out. They can stretch out the life of that particular retirement account that they inherited, allow the principal to grow tax deferred, and then they weren't thrust into higher tax brackets because they were the minimum distributions that were required to be taken out were lower, and sometimes lower than what yours were when you were alive. So that used to be a benefit. That's no longer the case. Why? Because non-spousal beneficiaries are going to be required to withdraw the full amount of money from an inherited retirement account within 10 years. Now, to be clear, not all non-spousal beneficiaries are going to be required to do that. So this new 10-year rule that was created, not everyone's going to be subjected to it. And there are certain exceptions. So spouses, number one. Any beneficiary that is not more than 10 years younger than you, so maybe like a sibling, a younger sibling that you have. Any beneficiary that's chronically ill or disabled, or if you have beneficiaries that are minors that have not yet reached majority age. Those will all be accepted, and they'll be able to utilize life expectancy and still basically follow the old rules. So the stretch out will still apply to them. The 10-year rule will not apply to them. One little note about minor children: once they turn majority age, then the 10-year rule kicks in and does apply to them. We're not clear what the majority age is going to be, what that is defined as. It probably will be state specific, and in California, it's age 18. So there'll be further information as that rule gets flushed out. We'll see other regulations. There might even be some litigation regarding that in the future. So we'll see. But conservatively, we can look at 18 right now. So why is this bad? Well, this is bad because now there'll be a greater tax impact for your beneficiaries that are subjected to the 10-year rule, which means that they'll get less value. They'll get less of those that money in the retirement accounts that you want to benefit them, because they'll be taxed at a higher rate, because they'll be required to take the money out much faster, which will thrust them into higher tax brackets. And so they'll be paying more tax outwards. So that's a problem. And the second problem is also that there's no longer going to be a safe haven for these retirement accounts. Previously, with the stretch out, in addition to the tax benefit, was the fact that these accounts were safe havens from other drivers on the road, other creditors and predators, people or things or life events that were going to take that money away from our beneficiaries, whether it's a divorce, a bankruptcy, or a lawsuit, or in some cases the beneficiaries themselves and mismanagement due to inexperience or youth or just spendthrift habits. These safe havens are going to be dissipated because the money has to be withdrawn within 10 years into the personal hands of the beneficiaries. So now they're exposed to all those liabilities. So that's why this is a big problem. Just think if you have a beneficiary who's a young adult or soon to be a young adult in their teens, going into their 20s, even early 30s. This could be very problematic if they don't have good saving habits, or they recently got married, or you don't have those protections surrounding them. So this could be a way in which large retirement accounts that are left to children or grandchildren just go up in the ether because there aren't these safe havens anymore. And that's different and separate from the tax problems. So what can you be doing right now to solve these issues? Number one, you should be reviewing your beneficiary designations. Take a time out, go and look at them, find where they're located, find them out, and then start reviewing and have a conversation with the big three in your life: your estate attorney, your financial advisor, and your CPA. So you can come up with a good strategy for you as far as how you want to name your beneficiaries, because the purpose of your retirement account and the purpose of leaving money for your beneficiaries is really what needs to be examined so you can know what the solutions are. There are a number of estate planning solutions, and looking at reviewing your revocable living trust if you have one, because that one is going to most likely be outdated now in light of the Secure Act. There'll need to be some updates. To creating other irrevocable trusts for retirement accounts could also be a potential good solution. And looking at other financial solutions such as leveraging life insurance as an offset to taxes, to talking to your financial advisor about potentially pursuing Roth conversions, or if you're charitably inclined, looking at how you can use your retirement accounts to donate to charity, whether that's directly as a beneficiary or utilizing some estate planning by creating charitable remainder trusts. all potentially viable solutions, but all require a good conversation with your estate attorney, financial advisor, and accountant. And so that's what we would recommend. There'll be more on this to come as we deep dive into some of the problems in a little more detail to give you more examples, deep dive into some solutions that you can pursue. There'll also be some webinars upcoming on this, so stay tuned. But just wanted to get you a little bit of more flavor on this because it's super, super important. So if you do nothing else, pull out your beneficiary designation forms and get them in hand so you can take a look and know exactly what they are, because at a basic level sometimes we're all surprised when we do that because we've forgotten how we initially set them up, and they might not be how we want them just normally, never mind anything to do with what I talked about today. But it's a great opportunity to begin the conversation. So there's your homework. All right, my name is Kevin Snyder of Snyder Law. I'm an estate planning and elder law planning attorney in Irvine, and I help families plan to protect what matters most to them, their loved ones, their dignity, and their legacy, and happy to help you in regards to the Secure Act moving forward. So have a great day. Hopefully this was valuable for you, and I'll be hopefully talking to you soon.